For the appellant,
Vic Pryor for the appellant, Your Honor, for Campbell County, for appellant Sonya Harness. Reserved 5 minutes for rebuttal.
thank you.
Your Honors, this case involves a appeal of a summary judgment from the Morgan County Circuit Court involving issues of uninsured motorist coverage. The facts are undisputed, but it would be beneficial to the court, I think, to go into the facts briefly. Ms. Harness was an employee of volunteer staffing, her employer as a home health nurse when she was involved in an automobile accident with John Mansfield. We filed suit against Mr. Mansfield as well as her personal insurance carrier, which is Tennessee Farmers Mutual, and Cincinnati Insurance Company, which is the liability carrier for the employer volunteer staffing. At the time of her motor vehicle accident, she was in the course and scope of her employment, and there's no dispute that she was covered by liability coverage by Cincinnati Insurance Company, the employer's carrier. Cincinnati had written a policy for $1 million covering liability, and it also included in the policy, as required by statute, the written rejection form which entitles the policyholder to reject or limit the uninsured motorist coverage. The rejection form was not signed. What the employer did was create some policy documents which were a designation of a vehicle, a provision in the policy that indicated on the business auto coverage form, number 7, only vehicles described in item 3 of the declarations which a premium is charged are the vehicles that will be covered with uninsured motorist coverage.
That's the Honda vehicle you're talking about?
That is the Honda Odyssey, Your Honor. Ms. Harness was driving her own Chevrolet Trax automobile and received significant injuries.
Who is the owner of the Honda?
The owner of the Honda was the employer, volunteer staffing.
Okay.
There were several vehicles that were driven by employees of volunteer staffing. They were owned by the employees, and all were required to drive their own vehicles as part of their employment. Ms. Harness carried liability and uninsured motorist coverage as required by the statute, like everybody is required to do. Both uninsured motorist carriers, Cincinnati Insurance and Tennessee Farmers, filed answers to our complaint. Both have denied coverage. Cincinnati filed a motion for summary judgment asserting various defenses, and the Circuit Court for Morgan County entered a summary judgment to them, granting them summary judgment based on the provisions of TCA section 577-101B2, which states, with respect to bodily injury to an insured while occupying a motor vehicle owned by the insured, only the limits of the uninsured motorist coverage on the vehicle in which the insured was an occupant shall apply. The interpretation given to that by the Circuit Court from Morgan County was Ms. Harness was restricted solely to the insurance she carried on her own vehicle, and granted summary judgment on that issue. We have found no authority except for one case in the state of Tennessee addressing this particular statute, and the case that addresses it is the case of Ferguson versus Jenkins, cited in the materials in our brief. The case Ferguson versus Jenkins involved a person that owned an automobile, sold various vehicles on the lot, bought a motorcycle, and insured it at the time, the insured, but he bought the motorcycle to sell it on his lot. The lot policy provided coverage for after acquired vehicles that were purchased for sale on the lot, and ultimately it was decided that the motorcycle was purchased for sale on the lot and the lot policy would apply. The court also said that the interpretation that was attempted to be given by the uninsured carrier in that case, which was that the owner was restricted solely to the personal coverage on the policy that he had. The personal policy was a misinterpretation of that statute. This is the only case that we've been able to find in Tennessee on this particular issue.
Counsel, before we get too far down the road in the anti-stacking statute, I do want to ask you sort of a practical question about how your argument on the rejection in writing works. So in a circumstance like this, where the insured only wants coverage for a single vehicle in a fleet, let's say you have an insured that has a multi-vehicle fleet, but they say, you know what, we only want half our vehicles because they're the ones that are going to spend the most time on the road to have coverage. How would they do a written rejection in that case? Would they say, wouldn't they do it exactly like they've done it here?
I appreciate your question, Your Honor, and that's a question that was asked me by the trial court, and frankly, I don't know the answer to that question. They perhaps could write separate policies for those vehicles. They could. I don't write insurance policies, so I'm not an expert in this. They could write some kind of endorsement.
Well, the reason why it's got me scratching my head is because the statute is written in terms of a complete rejection of coverage, and here, it's clear that the insured did not intend a complete rejection for sure.
It's clear that, well, it's not clear because the statute requires there to be a written rejection. If you reject, they're saying there was no rejection because they covered one vehicle. It was a rejection to my client. There was a rejection to all of the other vehicles on there. They're not calling it a rejection, but it's a de facto rejection. So I don't know how you accomplish that according to statute, but the statute says every automobile liability policy issued in Tennessee covering liability arising out of the use of a motor vehicle shall be covered with uninsured motorist coverage. So that's what the statute says. And then in the rejection portion says the named insured may reject. There was no rejection according to the statute, but there was certainly a de facto rejection based on this single vehicle that they put in the policy. I think my client being covered with liability, I think she's entitled to protection of the act. Now, how to get around that problem? That's a problem that was addressed to me by the trial court.
I see. So you're not clear on how. So let's get back to the anti-stacking statute.
Well, I was just going to say the anti-stacking, if that's what you want to call it, that's how I characterized it. But in Ferguson versus Jenkins, the court said, where the insured may purchase a business policy and a policy with the same limits and rely on the limits to cover the minimum policy on the vehicles, customer misconstrues the statute. This statute applies to a situation where the owner of the multiple policies is attempting to increase the stated limits of the coverage. And the example that's given is if there is a commercial policy like this and you have one or personal policies, you can't use this commercial policy to increase.
Yeah, I don't read that statute as being an interpretive statute at all. It seems to deal with the circumstance. This case is all about whether or not that statute can apply at all, right? Because first you've got to make the determination is, are there multiple coverages?
Correct, and you've got to presuppose that this is the only policy that would apply before you can even use the statute.
So it seems like it would be circular if you said, well, you look at that. Okay.
But the case says that's a misinterpretation of the statute, and this is the only case we have in Tennessee. As far as the failure to obtain, got out of time, but as far as the failure to obtain the rejection, we'll stand on the Dunn versus Hackett case, which says absolutely, if there's an insurance policy written, the only way to reject that is a rejection in writing. I think the Dunn versus Hackett case is dispositive of this case, and we'll stand on that case. I'm out of time.
Okay. You do have your rebuttal, though.
Good afternoon.
Yes, sir.
I'm Jason Farrell of the Nashville Bar, here for the Cincinnati Insurance Company. So just a few things. It's my client's opinion that the statute is very clear in the words that are contained in it and what it means.
But how does it resolve the sort of baseline issue about whether or not there's coverage or not? I mean, it seems like to me that you make first a determination of whether or not there's multiple policies or not. It doesn't resolve the question.
Well, and perhaps I don't understand your question. If it's only going to apply when there's multiple coverages. And then if you're in the vehicle that you own and you have coverage, your policy applies. If there is another policy, either your own policy on another vehicle or a policy that's your employer's coverage, of course, we contend there's no coverage, then your own coverage applies. This is an employer's policy. Really the employer has this policy, has liability coverage really to protect its own interests, of course. It has its coverage because it has a car that no one else is providing coverage for. Its employees presumably have coverage on their own cars. So we needed to get coverage. So that's sort of the situation we're in. So I guess this sort of works out so that everyone has their own coverage. There's no duplication in coverage.
Right, but we only worry about stacking if there's something to stack, I guess is the baseline question is. And the first question we need to determine is, okay, is there UN coverage under the employer's policy?
There's not.
Well, there is, but your position is it's just one vehicle.
There is coverage for this 2004 Honda Odyssey.
Yeah.
And if the employee were driving that vehicle, she would be covered. And because she was not driving that vehicle, she does not have coverage. Policy is clear. Going back to the statute again, that sentence and what it says matches perfectly with the other insurance language that's in the Tennessee uninsured motorist other insurance language. It says if you're in your own vehicle, you have your own insurance coverage, that your own policy applies. Those match perfectly. I was just say one thing about the rejection. How do you ask the question about how do you reject it when you have a fleet of cars and you just want to have coverage on one car? You do exactly what happened here. That's what you do. You get the coverage that you want on the vehicles that you want coverage on. And I'll mention to you the statute. Part A says, I'll just sort of paraphrase it, every automobile liability insurance policy delivered shall include uninsured motorist coverage subject to provisions filed with and approved by the commissioner. So the commissioner can approve these policies to have language that can limit things in there, such as not having duplicate coverage, which is what we have here. We have the policy that essentially creates situations where it does not apply and duplicate coverage when someone already has coverage. Ms. Harness probably had no idea that Cincinnati Insurance even existed. I'm quite sure she had no idea that she had that there was a potential of uninsured motorist coverage from Cincinnati when she was out riding around.
But this question only is pertinent, if I understand correctly, if you work under assumption that there is some coverage for her under the Cincinnati insurance policy, correct? I mean, we only worry about the statute.
That's correct.
Okay. And the statute itself doesn't provide interpretive assistance. I mean, I get it, that you're saying that the policy behind, you're describing the policy behind the anti-stacking statute and how it matches up with coverage generally. But, first I've got to resolve the issue. Okay, I'm looking at Cincinnati Insurance's policy. Is there coverage for this vehicle? That's the baseline where I start. And if the answer is no, do I have to do anything else?
No, that's it. You can stop right there.
Yeah.
You can decide there's no coverage based upon the plain language of the policy and the fact that Cincinnati met any rejection requirements under the statute because it obtained uninsured motorist coverage for the vehicle that it's insured, presumably wanted to insure. Just to respond to a couple of things, the Ferguson case, that is the only case I know that talked about that statute, but that was a case where there really wasn't talking about, it was just an issue whether those covers, there wasn't really a limits issue. It's really just about whether.
Yeah, it was, Ferguson gets Jenkins. I keep wanting to say Ferguson Jenkins because it's a great pitcher for the Cubs, but that's about what a garage policy or an individual which was going to cover here. Right. So you really don't get into how the mechanics of that how that statute is supposed to work.
Exactly.
Okay.
And there was another thing, a case I want to mention that I referenced in my brief, but I did not, mistakenly, I did not talk about this. It's the Holloway versus Purdy case. And that was a case involving a garage owner's policy. And that case said that you can limit coverage to only certain vehicles. So I printed it out.
Well, and that's you cited that in your brief.
I cited
Counsel.
it, but I did not spell out for this reason. That was a case where, I forget if it's a repair yard, tow yard, something, and the garage had coverage on owned vehicles, and the insured drove a customer's vehicle outside of the garage, I guess to get a part or test drive it or something, had an accident, and the garage policy's coverage was found to not apply because the customer's auto coverage applied. So I thought that case might be instructive. And that was out of the western section. And what it said, the court said, in this case, the customer's car driven by Mr. Holloway at the time of the accident was insured under an automobile policy with uninsured motorist coverage that applied to cover Mr. Holloway. If we were to determine that the limitation issue conflicts with the provisions of the Uninsured Motorist Act, that would result in coverage under two policies. And so the statute explicitly allows limitations designed to avoid duplicate coverage. So I jumped around a little bit, but that's in that case. I want to point that out to you as well. And I could quibble a little bit about the Dunn case, but you can read it as well as I could explain it to you. But that's really all I have unless there's any other questions.
I hear none. Thank
Okay,
you.
thank you.
Your rebuttal?
Yes, Your Honor. I would like to address the Holloway versus Purdy case. The Holloway versus Purdy case is a duplication case. I read it again, and in my reply brief, I did not analyze it correctly. It is a duplication case, and what occurred in that case was the owner's policy. The shop owner was covered by the owner's policy as a permissive user. The owner being the basketball coach at Memphis State, where I went to school, by the way, Larry Finch. It was noted in the case. Anyway, the shop owner's employee was covered as a permissive user, and therefore it's not analogous to this case, because that's a purely a duplication case under 56.7-1205 to eliminate the duplication. That case does not apply to this scenario. He pointed out that the commissioner had approved this policy, as they do all of them. But if you look at the case of Fleming versus Yee, in multiple cases, it says the approval by the commissioner is not dispositive of whether or not these cases are in violation of the law. And the final thing I want to point out to your honors, and I appreciate your time, is what we have here is a rejection. Without admitting it's a rejection, it's a de facto rejection of everybody else. They're asking for them to be able to write a policy that says the vehicles for which we get paid a premium are the only vehicles we have to cover with uninsured motorist coverage. I say we submit that as abhorrent to the statute. The statute requires all vehicles that are covered with a liability policy to be covered by UM coverage, unless specifically stated in writing, including in the policy. The Dunn case says when the legislature said it has to be in writing, the legislature meant it, and then they are trying to usurp that. They're usurping the statute and trying to limit it to one vehicle, when the statute requires them to cover all vehicles unless the UM coverage is rejected in writing, and we think it's abhorrent to the statute. It's our position. Any questions?
I hear none. Thank you very much. I want to thank you both for your presentation before the court. And now your case has been submitted for resolution. You should hear from us by way of opinion in this case within a reasonable period of time. Thank you. You may be